dividends received from the company. If you think about it, in the right circumstances, the 831B election can lead to phenomenal estate planning benefits for your clients. And this is the reason that the Trust Task Force 3 years ago got involved in this, and I got involved in this in the subcommittee that led to the Lieutenant Governor's task group that led to the bill. Captive insurance companies can be structured exactly the same way as family limited partnerships. You can give the children highly restricted interest in the captive insurance company, which increase in value, but there's no estate tax implications because no one has died. There's no gift tax implications other than if dad and mom pay the $100,000 to originally capitalize the company. Because the insured business is purchasing a product, it's purchasing that captive insurance for fair market value, and there's no GST tax. So think about what you can do. Father's business deducts $1 million of insurance premiums. Deducts it from bottom line. That $1 million, you go to a captive insurer that's made the appropriate elections under 831B. So that entire $1 million flows to the captive insurer, probably a trust captive insurer held in trust in a South Dakota trust, and not a cent of that $1 million is reported for income tax purposes. Now there are going to be some expenses, obviously, and we'll get into those, but administrative expenses, purchase of reinsurance. But if you set it up right, let's say that 40% of that each year ends up being profit. So $400,000 a year has gone into this trust for the kids and grandkids. Father hasn't even touched any gift tax or estate tax exclusions. In fact, he's gotten to deduct it from his income tax. And after 5 or 10 years, look what we've done in our planning. So it's a type of asset that's ideal for trust planning. And again, because of South Dakota's law, the administrative and regulatory burdens are very low, especially if it qualifies as a trust captive. Now, from pages 19 to 23, I'm kind of going to skip those. That deals with a lot of revenue rulings, and it's there if you want to read it. You need to understand those, but what those deal with is basically what it takes to be insurance. And there are numerous people who've set up captive insurers. The two key things, insurance isn't defined under the code, but it has to have risk shifting and risk distribution. There's a bunch of revenue rulings that talk about risk shifting and risk distribution and how safe harbors to do that. But I'd like to go to page 23. What did South Dakota do? About 40 states have captive insurance laws, with more joining the list all the time. South Dakota's law has been on the books for 17 years, but until July 1st, 2013, when our last when last year's law came into effect, we had 4 captives. Since that date, at the time that I wrote this, there were at least 4 new filings. I spoke to the Division of Insurance 2 days ago. They've got, in addition to those 4, they've got 8 more in the works. It's a tremendous growth of captive filings because of what South Dakota's done and South Dakota's forward-looking laws. First of all, South Dakota added new concepts. We're the first state to statutorily recognize a trust captive. Other states, have allowed captives in trust, but we statutorily recognize it, and we put certain lessened administrative requirements on trust captives. We've got administrative costs in South Dakota as lower than any other state. We've got a lower tax than any other state. We've got 3 new classifications of captives which allow structures and organizations not previously allowed, and allow your flexibility and creativity to form this, so long as the Director of Insurance determines that the risk or hazard is acceptable and financial solvency and stability are adequate. Captive insurers are regulated, but the best analogy I can give you is it's like a private trust company where the owners of the trust company and are the beneficiaries of the trust. If the trust company screws up, you're not affecting the general public, you're affecting the people that own the trust company, and there's a lot less both reputational risk and a lot less risk that they're going to sue themselves. That's similar to a captive insurance company. If for some reason the captive insurance company can't pay its claims, you haven't, and the regulators recognize this, that you haven't affected the general public. It's not like if State Farm Insurance or Geico go bankrupt. You're only affecting the individuals who actually own the company. And I don't mean to make light of that, but I think that that's underlying some of the concepts that we've made. We don't want any of these to go under, and I'm not suggesting that they receive less regulatory scrutiny, but as a practical matter, you're not probably going to have a lot of claims from such private entities, or at least you're not going to affect the public interest as much if there's a failure. So under South Dakota's revised laws, 5 types of captives are allowed. And if you turn to page 24, the first type is the pure captive insurance company. This is one where there's a common owner, owns both operating business and insurance company. It's a pure captive. Second type is at the bottom of page 24. It's an association or group captive. Businesses A, B, and C get together and form a group captive and may reinsure separately, and there's a group pool for reimbursement. The third type, this is also, I guess, a second type. It's association and group captive under our law, is the association captive. That's at the top of page 25. That's similar to ALPS. The Insurance Association has members. The association members pay premiums, and the association captive may have ownership in the association. At the bottom of page 25 are sponsored cell captives. These are new to South Dakota, and sponsored cell captives are, it's kind of like you've got a mothership and you've got a bunch of silos under it, and each silo is its own cell. So the liability of silo number 1, if there's liability, it cannot go into silo number 2, but they're all administered under the mothership. Under South Dakota law, a cell captive will pay an annual fee of $5,000 for the mothership and $500 for each cell. But again, the key difference is that each cell cannot be responsible for the losses in cell 2. So if you have a Marco's Pizza and Joe's Upholstery and Tom's Law Office isn't responsible for the losses in the Marco's Pizza cell. At the top of page 26, talks about trust captives. This is one of the most unique things, and it's new to the South Dakota law. And this is also the illustration of the mini captive that I gave you. The operating business gives $1.2 million deduction to the captive insurance company, which is held by an irrevocable trust for the children. As stated at the bottom of page 26, you can see the estate planning ramifications. There's a deduction for the premiums paid, but the captive pays no taxes on the premiums received. And at the top of page 27, we've related this to estate planning, that part of it's inside the owner's estate, the rest of it is outside of his estate, and the growth also is outside of his estate, which benefits the children and non-children. Finally, South Dakota recognized a catch-all, which is a special purpose captive. And the special purpose captive is designed to allow flexibility when the director of the Division of Insurance is comfortable with the solvency and business plan of the captive. There are certain things the captive can't insure: life and health risk, personal lines risk. I have explained a couple of things on pages 27 and 28 of how, although you can't directly insure a health risk within a captive, if you've got a self-insured situation, the captive can indemnify the company for excess self-insurance, backstop it, if you will, indemnify above a certain amount. Again, since I prepared this to talk about we were talking to our clients in our office, I do have some considerations. This is not a one-year deal. It's a long-term deal. First of all, the benefits don't start being realized, built up in 1 year. So the client needs to be committed to that. Should be part of an overall risk mitigation plan for the client. The company needs to be committed to that, and it'll probably take several years for those plans to work. And the third reason is we're trying to avoid IRS scrutiny. We're trying to walk right down the middle of the road, and if you start and stop a captive, all that does is going to draw both unwanted regulatory attention and IRS scrutiny. And there are startup costs on this that we'll want to amortize. You have to have a client who's willing to take on additional corporate responsibilities. You know, some of your clients love annual meetings. Some of your clients say, you do the first annual meeting and I'm going to do them all from there on, and you know what's happening because they've got a lot of whiteout, and they can change things. Would you please send me those annual meeting minutes in a Word format, please, so that I can use them next year? So the client and the attorney have to be willing, because the captive insurance company is a separate company, it's a separate organization. You've got to be willing to meet those formalities, do things like minutes and reviews and policies and procedures. And because a captive insurance company has to be capitalized, the client needs to put money into it from day one. There are ways that loans can be done to do the money and things like that, but the simplest way, and the way that I've advised the clients that I've worked with on this, is, you know, let's commit to it and commit to it right and put in the money from day one. The steps to take in forming a captive are on page 29. I've given you the website address of the State Division of Insurance application. Normal things that you'd expect: financial information on the owners, officers, directors, economic feasibility study, an actuarial report, 5-year business plan, pro forma. We did work very extensively in the captive insurance law and there's a great confidentiality section that the information submitted with the application is kept confidential, is within the attorney-client privilege if there's attorney statements in there and things like that. But the first step is a feasibility study. Part of this will document existing coverages, existing limits, holes in coverages, general contract terms. There will be a history requested of insurance claims, and the actuary will provide potential insurance rates. This is conducted to ensure that the captive insurance company will be able to adequately insure the risks it protects against. It's a regulatory requirement, but also you wouldn't want to advise your clients to go into such a business without doing this. It's good practice to have this, and I tell you some of the things that need to be in it. The actuarial study will determine the appropriate premiums to charge for the risks based on historic risk levels. It's possible that following the feasibility study, the owner will determine the captive is not feasible or beneficial. So it's important that that study be done independently. There are many promoters out there who will tell you what you want to hear, but I don't think that that does our clients any service. We want our clients to form entities that work, and sometimes the hardest thing to tell our clients is that this idea won't work, but we want to have an analysis and an independent analysis to support whether the concept will work or not. Since most clients have never considered owning an insurance company, it's important to give them some insight into the environment. So the report will also contain tax information, and they need to have at least a high-level view of these issues to be informed owners. The other important thing about doing the feasibility study and the business plan is obviously it shows that the reason we're doing this is not tax avoidance. And I give you the Humana case is a really big case in captive insurance law, and one of the IRS claimed that Humana set this captive insurance company up solely for tax avoidance. They pointed to the fact that, well, geez, they went through this feasibility study, they did all these business planning, gave them all the advantages of this in their particular situation. You're going to have accounting projections and pro forma financials and the business plan. The business plan, one of the things, the reason the Division of Insurance wants it is to assure that the captive's operating as it was originally outlined, that you didn't form a captive to cover Medicaid, Medicare stop-loss risk and now got into auto insurance with your captive. It should incorporate a narrative version of the feasibility study, and the best plan is to look at the risks to which they're exposed and how they will be assessed and managed efficiently. So, page 31, I talk about organizational documents. There's a lot of choices under our law of ownership. For IRS purposes, you're going to have to check the box, the C corporation box. It must be taxed as a C corporation. But even in those cases, it can obviously have multiple classes of stock. But there's other tax planning opportunities. It can be owned in trust. It can be owned in a family limited partnership or an LLC. It can be owned by key management, as we talk about it at the top of page 32. It also can be owned by a business or statutory trust. I note that Tom Simmons later is going to be talking about business trusts and statutory trusts, but this is a form of ownership that's not much used in South Dakota, but in the appropriate case, it can really work well for a statutory or for a captive insurance company. And one reason that it can work so well is it's the only place that I'm aware of under South Dakota law that allows series, like in these cells. We don't right now have a series LLC law, and even if we did, there's questions whether that is appropriately enforced in other states where we're trying to argue our South Dakota LLC law if we have one. But statutory trusts are in every jurisdiction, and if you look at statutory trust law, it does allow for series trusts. So the capital plan you're going to have, depending upon the type of captive formed, the nature of the risks being insured, and the premium to capitalization ratio may be in the range of 3 to 1 to 4 to 1. Now, a trust captive minimum capital under the state law is $100,000. That's the lowest minimum capital of any captive insurance law in the country, and the reason that the trust captives that are kind of specially done is because they have to be with trusteed by a South Dakota regulated trustee, and the Division of Banking does a great job in regulating South Dakota trust companies. So basically, let's say you want to write $1 million of premium, you're probably going to need capital from $200,000 to $300,000, even though the minimum is $100,000. Obviously, if Dad, in this estate planning scenario, gives that to his kids, that's going to be a gift, because that's a cash gift. We're not getting around that. What we're getting around is the annual premiums where Dad gets to deduct, and the captive insurance company doesn't have to recognize his income. The law does provide at the bottom of page 32 for letters of credit to form captives. I just recite the law for you. I haven't worked with that at all. Probably now we're to what the client wants to know. What's this going to cost? That's on page 32. The right combination of service providers would probably be a domicile attorney with or without another attorney consultant, a CPA, a registered office and agent within the state, a director or manager located within the state, and a captive manager who may also provide actuarial services. The application to the Division of Insurance requires the captive's lawyer, CPA, and captive manager be listed, but we need to have expertise in accounting, actuarial, legal, insurance, and management. There's no single best combination. The domicile attorney, if you're hired to be the domicile attorney, you'll charge what you charge for creating the entity, obviously, the LLC or the corporation, the bylaws. You'll want to work with the captive manager on certain policy and procedures. The most important thing is that you get the expertise needed in forming these, but I said those costs could run $5,000 to $10,000, CPA and actuarial services from 2 to 6, may be covered in the captive manager's costs, and the captive manager who's actually putting together the feasibility study, the business plan, run anywhere from $15,000 to $40,000 up front. Ongoing services after the captive manager has started are $20,000 to $30,000 or more annually. CPA audit is required every 12 to 36 months, except for small trust captives. It's required every 5 years, and that's an ongoing cost. The application fee in South Dakota is $2,000 plus $1,000 for each cell if it's a cell captive. And we talked about the ongoing supervision fee of $5,000. So the startup costs are going to run $30,000 to $50,000 or more. Annual costs $35,000 to $45,000 or more. Just as there are business corporations with small administrative costs, There are some with larger administrative costs, and if the captive is feasible, the costs are going to be part of the business and should be more than offset by savings in premiums, increased coverage, and tax efficiencies. Ultimately, the cost is correlated to the complexity of the plan. One caution I found in this area is that it pays to consult with experts and it does not cost. If you dabble in this area without consultation, first of all, it's not efficient for your client. Secondly, it's probably unethical under Rule 1.1 on competence, and it runs the risk of invalidating everything. Not only, you'll see in Appendix 5 of a situation where some lawyers were indicted for doing this. Not only is this does it cost your client, but if the deductions are thrown out, you're paying penalties, you're paying interest. Most areas of law or any other professional service, the more specialized situations take more expertise with firepower. So I've got a page and a half of cautions on page 34 of not using standard forms, trying to work things out for your specific client's situations. But one of the keys is at the bottom of page 34. South Dakota Division of Insurance has indicated a willingness to vet the proposal and to discuss applications in draft form before they're submitted and finalized. I think that you should always take advantage of this. If there's any unusual questions, I'd vet it before we even got to the feasibility study. I'd call them up. The regulator's been supportive of captive insurers. The regulator was part of our task group that proposed the legislation. As with most regulators in South Dakota that I've worked with, they don't cut corners. They do put the applicant through their paces.